start with our questioning. Mr. DeMarco, under Section 4617 of the Housing and Economic Recovery Act of 2008, the conservator or receiver of the GSEs may disaffirm or repudiate any contract if the conservator determines that the performance of these contracts is burdensome and that the repudiation of the contract will promote the orderly administration of the affairs of the GSEs. You actually evidently made a determination that this was, that paying these legal fees and continuing to defend these individuals was not burdensome to the corporation. How do you justify that?
Mr. Chairman, yes, that determination was made. It was made at the time the conservatorship was established by my predecessor, and the determination was made by my predecessor for the reasons that are outlined in my testimony, that that this was, the advancement of legal fees was required by FHFA's own regulation, that the indemnification that was in place was required by FHFA's own regulation, was consistent with Fannie Mae's bylaws, and was at that point a requirement under applicable state law. So the determination was made at that point, and that's not at this point a determination to be revisited.
Now, we keep talking about Fannie Mae's bylaws. I want to read you something that's also from Fannie Mae's bylaws. For example, it states that the indemnification will not be provided when the officer or director breaches his duty of loyalty to the corporation, acts or fails to act in good faith, and engages in intentional misconduct. Now, I know that you have read the OFAO report, and this is the copy of the report, and all of these tabs represent areas where the three individuals that you're continuing to pay legal fees acted in ways that were not in the best interest of the corporation, and to me violated the very bylaws of this corporation. And so for the determination to find that that's not burdensome, and that in fact that these contracts should be honored, is a little puzzling to me, and I think it's a little puzzling to the American taxpayers, because they're continuing to pay fairly substantial legal fees for these three individuals who, according to this report, weren't doing things that were in the benefit of the corporation, and ultimately the taxpayers had to come into the tune right now of about $150 billion, and that total could go up. And so I'm still trying to figure out how you felt like that was in the best interest of the corporation.
So, Mr. Chairman, fair question. I think that my written statement, which goes into some detail in defining indemnification, defining the grounds under which indemnification would be denied, may be helpful here. But let me try to summarize, and then if counsel wants to supplement, that may be helpful as well. But essentially, indemnification is something that actually takes place at the conclusion of a judicial or administrative activity. Now, there are two areas in which the actions of these former executives have come under review. The first is there was an administrative notice of charges that was filed by FHFA's predecessor agency, OFAO, based upon the findings in the report that you referenced. Those notice of charges were made in December of 2006 and ultimately resulted in a settlement in April of 2008, a settlement with the three former executives that resulted in payments by those executives, but did not result in any finding or admission of the breaches that would violate, that would meet the standards in the bylaws to avoid indemnification. The litigation that is ongoing today, the multi-district litigation that is a subject of such attention here, is in fact to determine the behavior and activities of these former officers and whether they did breach. So the finding that would be the predicate for denying indemnification has not taken place yet, because we are in fact in the midst of such litigation. Therefore, what is going on right now is an advancement of legal fees, and that is very much required by contract and by law, and the advancement of legal fees will continue until the conclusion of this judicial action. When there's finality to that, based upon what the outcome or findings of that may be, there would then be a determination as to whether indemnification of these officers would be provided, or whether there are grounds to seek repayment of the advancement of those fees. But that cannot take place while this is in process. It is something that takes place at the end of the legal process.
I would also say, though, that you could have denied advancement. Or if you weren't going to repudiate the indemnification, you had the ability to say to these individuals, you know what, we got a little problem here. We're broke, and we're not advancing additional monies for these fees. Right. Obviously, I think that right. brings some incentive for those individuals not to keep burning taxpayers' money.
Mr. Chairman, I certainly understand the issue and the concern that you're raising there. I would simply say that the determination at FHFA was that to cease advancing those legal fees would have resulted in suits against us, and operating with the responsibility as conservator, we determined that looking at the legal case law here and the facts and circumstances and what governed in terms of contract law and other applicable law, what needed to be done was to continue advancing those fees. That's the determination that was made at the time the conservatorship was established. FHFA did affirm that for the company, and so we continue to operate with that affirmation in place.
My time has expired, Mr. Capiano.